introduce myself. So my name's Richard Gordon. I work for Gibson Sheet Lawyers. I've been there for about 4 years now, and I'm involved in the sports, the commercial, and the employment teams. So hopefully right on topic for what we're going to be discussing today. And before then, I worked for Wellington Rugby and the Hurricanes for a number of years, and I also am a volunteer rugby referee here in Wellington. So I'm just going to jump into a PowerPoint presentation. If this works. I hope everyone can see my screen now.
Yeah, we can.
Excellent. So firstly, I think there's been a lot of confusion around the wage subsidy and a lot of the other initiatives that the governments have introduced, and that's to be expected in one way, because they're trying to do things quickly, and when you do things quickly, it's not always done exactly right. But in this case, I think speed was good, even though we have had a lot of confusion and ambiguity. I have to say there is still some confusion around the exact terms and conditions of the wage subsidy, but I'll run through what we know, and I'll make it very clear if there's still a question mark around some things. So firstly, who can get it? When they initially brought it out, it was only companies and businesses that could get their hands on this money, but that changed relatively quickly after they got some feedback, and it's been extended to all sorts of entities. So registered charities can get it. Trusts can get hold of it, self-employed and sole traders, contractors, and importantly for us, incorporated societies can apply for and get the wage subsidy for its employees. The eligibility for it, there's a list of the things here that you need before you're eligible to apply for the wage subsidy. Your organisation needs to be registered and operating within New Zealand, and if you're an incorporated society, that means you need to be registered with the Incorporated Societies Registrar, which I imagine most are. Your employees must be legally entitled to work, which basically means that they're either a New Zealand citizen or resident, or they've got a valid visa to work in New Zealand. And then importantly, there must be a 30% decline in actual or predicted revenue for any month between January to June this year compared to that same month last year. And then that decline needs to be related to COVID-19. Now, we're not exactly sure what related to COVID-19 means. I think, and we're all on the same page in our office, that this is quite wide. So if it's a flow-on effect or a knock-on effect from the shutdown, then it's going to be related. I wouldn't be too worried about that part of the qualification, as it's quite wide. And if you have suffered that 30% decline, it's almost certain that it's due to COVID-19. The next step for eligibility is you must have taken active steps to mitigate the impact of COVID-19 on your organisation. There's a number of ways that can happen. It could be, looking at your savings, if there are any savings. I understand that in the sports world, it's a day-to-day, week-to-week, month-to-month kind of thing.
And arrived with dinner yesterday, so that was fun too.
Sorry, what was that?
Carry on, Richard. Just a reminder for all attendees, just make sure you mute your microphones and turn your cameras off just while Richard's talking. Thank you.
Other ways you could show that your organisation has looked to mitigate the impact is maybe contacted insurance, if there's any help to be had there, or your bank, or sought advice from your accountants or legal advice there as well. Now, in terms of what happens once you've accessed that wage subsidy, the current criteria is you must retain the employees named for the period of the wage subsidy. So if you receive the 12-week lump sum payments for 6 named employees, you must retain those employees for the 12 months. The 12 weeks, sorry. Now, that wasn't initially a requirement. The initial requirements, and this changed, I think, less than a week after the wage subsidy started, was you had to try your best or try your hardest to retain those employees, that changed pretty quickly to no, you must retain those employees named for the period, even if it's just paying them the wage subsidy and nothing else. And the criteria still states you should try your hardest to pay at least 80% off wages, although I think the government has been reasonably practical in that they understand that in some areas that's just simply not possible, and that's why they've changed to no, you must retain those employees even if it's just paying them the wage subsidy. So repayments, the government require you to repay the money if you weren't entitled to it or you stop being entitled to it. So the first half of that is if you were not entitled to it in the first place. I think there's been some anecdotal remarks and articles about certain businesses applying for it where they possibly shouldn't be. What comes to mind, I think there were rest homes that hadn't suffered a decline in people that were staying in the rest homes, and therefore it would be potentially difficult for them to show that 30% decline. And others were some private schools, I think, were still charging school fees and had also applied for the subsidy. So for them, they'd have to show how exactly they'd suffered that 30% decline. And I think what we will see in the wash up of all of this when they run a proper auditing process is there are some employers that have accessed this as oh, we should do this anyway, it's free money, and they may not have been entitled to it. Now, the second half of the repayments is if you stop being entitled to it. And that's an interesting one. Initially, we received some advice from the government that if an employee left for any reason during the 12 weeks, whether that's resignation or say through a redundancy, the money could be kept and applied elsewhere. Now, we're not sure that advice is correct and we haven't got clarification. If an employee leaves during the 12 weeks for whatever reason, then we recommend that money's held separately until we can work out, or until there is a clear position on what happens in those circumstances. And the other little note about that is if, I think the figures are 585 roughly for a full-time worker, which is someone who works more than 20 hours a week, and it's 300 and something, 320 maybe for a part-time worker who works less than 20 hours a week. Now, in some circumstances, the 300 and something might actually be more than the part-time worker does in a week. And interestingly enough, the government has provided some advice that says, well, if it is more, keep the difference and apply it to paying your other staff their wages, which is really interesting because it kind of is a bit inconsistent with repaying money when you don't need it, but helpful, I think, for organisations. And the last point I've got here about the wage subsidy is just privacy. You do have to give the government or Work and Income some personal information about your employees. Name, IRD number, and there might be one other piece of information there, and therefore it's, if you have done it, if you haven't done it yet, it would be good just to get the consent of your employees to provide that information to Work and Income. It is a requirement that happens, although I can imagine many organisations have skipped that step out and nothing will really happen there, but best practice is to get the consent of your employees before you provide that personal information to Work and Income. And just as an overall point for the wage subsidy, we've been advising all of our clients that it's a really good thing just to keep thorough records of exactly what your organisation has done and for what reasons. So a document somewhere, it could only be one page saying, yep, look, we're applying for the wage subsidy. It's for X, Y, Z reasons. And we've taken A, B, C steps with our employees, and this is what we've done to, try and mitigate the effect of COVID-19, just so you've got that 1 or 2 page document that sets out what you did and why you did it. So if you do get audited and there is some kind of audit process, you've got that clearly there already. And that shouldn't take long. And I think it's a really helpful document to have in your records. So if we move on to employment obligations throughout this period, or other employment obligations, the first point is that employers' obligations to employees are not affected by this at all. So employment law and everything to do with employment law remain in force. And that means, the duty of good faith still remains, meaningful consultation between parties, and no unilateral decisions. They're still all there. I think if you've been keeping tabs on stuff in NZ Herald, there's all sorts of employment articles popping up saying you can't just unilaterally reduce people's pay or bully them into it. I think there was one this morning about bullying people into taking pay cuts. So yes, employment law in its entirety still applies. You can't take too many shortcuts. I will get into where you can possibly take some shortcuts coming up soon. So I think the biggest one here for everyone would be pay reductions and reductions in hours. That's what we're seeing very, very common across all sorts of organisations and entities. The easiest way to do this is to seek agreements with the employee or employees. I think it's quite rare in these current circumstances for employees to disagree when it's fairly well known that the next step or the alternative to a pay reduction or a reduction in hours would be more drastic than that and possible redundancy. While I don't necessarily recommend you say it's this or redundancy, I think to have that as a possible other alternative is fine. But the best thing to do in these situations would be to seek agreements. And that's, here's what we're planning on doing. Here's why we're planning on doing this. We want to hear from you if you've got any questions or other options. Otherwise, please let us know if you agree or not. And have all of that in writing from your employees. That shouldn't take too long. From our knowledge or our experiences, it's a 1 or 2 page document out to employees, and through our experience, we've seen really high uptake and buy-in from employees, given that most employees know that if they want to still be working at that organisation later on, it's in their best interest to help the organisation as well, especially in sport, where every cent is crucial. And unfortunately, we won't see every single organisation make it through this time. If you don't have agreements, if there are 1 or 2 or several employees holding out, yes, you can still do it, but you have to run a proper process first, similar to a redundancy process. And I'll talk about that a bit later on, but essentially that's, here's our proposal. We'll consult with you, receive feedback, and even if you disagree, we're still probably going to make this decision. But I think the best way to do it first and foremost is to seek that agreement from everyone, rather than running through a process where you're imposing a decision, which is still legal. So if I move on to the process in a bit more depth for redundancy and pay reductions, there is a bit of flexibility here. So normally with a process for redundancy or pay reductions or similar, which effectively are the same thing under employment law, it's a technical redundancy to reduce someone's pay. There would normally be a proper process which takes anywhere between a month to up to 3 months, depending on the size of your organization. So what it would be is, here's the proposal of what we're doing. In bigger organizations, it could include a structure chart of the organization and who works where, and these roles potentially might be affected. And here's the reasons why we're doing this, and several reasons could be, well, this person can take this work and or this role can be incorporated into other people's roles, or there's no rep sport this year at all, so we don't need the person that does the rep sport role anymore, or we don't need that role, sorry, rather than don't need the person. there could be various reasons why organisations look at a redundancy. And then after you've presented that proposal to staff, if it's just one or two staff, you would do it individually in a meeting. If it's the whole organisation that's affected, you might want to do a presentation. You'd then allow a period of time to seek feedback from staff. That could be between, well, it's usually around 2 weeks. And then you'd give yourself some time to genuinely consider that feedback before making a final decision on the proposal, and then working through the ramifications for all the affected individuals and whether or not there's other opportunities within the organisation and what else you can do to help. So that process, if you were running it not currently, could, as I said, could take anywhere from a month to up to 3 months. I think everyone, including the government, acknowledges that the process can be a little bit truncated in terms of timing under the current circumstances. So we've seen examples of, here's the proposal, 2 or 3 days to come back to us and we'll confirm the decision 24 hours after that, and done in a week kind of thing. And I think that's fine, as long as you're still following the proper process and getting that consultation and that feedback from the employee or employees, and you're genuinely considering that feedback, and they've had an involvement in the process throughout. As long as you stick to the requirements of the process, I certainly believe the timings can be shortened. However, when I am talking about redundancies here, if the affected employee or employees has received the wage subsidy, or you have applied for the wage subsidy on behalf of them, you do have that requirement to keep them employed for the period of the wage subsidy. So the redundancy sort of thing is something to be looking at a bit closer to the time of when your wage subsidy expires. And I also should note that there is a possibility the government would extend the wage subsidy, but we don't know any details about that. So that's a bit of a wait and see there. Could you simply seek agreements? I mean, we have seen examples of businesses going to their employees saying, hey, look, we've got no work for now, and we won't be able to work for a few weeks. Can we just pay you the wage subsidy and keep you on until we restart again, and then we'll get back in touch? And employees in the situation are saying yes to that. It's in their best interest to keep a job and hopefully get some more work later on, rather than going down a redundancy route. So even though you might have a proposal as to what you think is the best option, you might actually get some really good feedback from employees about alternate options and consider those. Other assistance for incorporated, I'll just jump back a step. I had contractors and volunteers in here as well. I think volunteers are going to be more important than ever going forward. I think, we all know that most sporting organisations couldn't exist without the volunteer base that underpins them. From a legal point of view, the legal position regarding volunteers is unchanged. However, I think this raises a health and safety issue, which I'll talk about very soon, or certainly it makes health and safety more important in the current climate. Contractors, they can apply for the wage subsidy themselves. So if they weren't able to fulfill their contracts at the time and they weren't being paid for that, they can apply for the subsidy and make up some of their shortfall that way. Can an organisation terminate a contractor? Some organisations will have contractors, and that relationship is really governed by the contract. So if the contract is still fulfilling the obligations under that contract, they are entitled to be paid for it. If they're not, then there'll be some sort of agreement or arrangement where they're not being paid, as if they're not fulfilling their obligations, they don't get paid. And then the termination of those agreements is a lot easier than terminating an employment agreement. It's usually specified in the agreements as a notice period, and the most common we see is 1 month notice for termination. Again, if you're going or you're looking down that route, it just be the first step would just to have a chat with them and just see, look, we don't have the money for this work, or this work's not happening for whatever reason. Can we put this on hold? Maybe it could be in your best interests to have it on hold and restart it at a later date, rather than simply just terminate the agreements and sever ties. So just on health and safety, it still applies to volunteers and contractors in your organisation. So if your organisation has even one employee, health and safety obligations extend to volunteers as well. If you're entirely volunteer organisation, then there's a bit more leeway there. So your organisation's health and safety obligations do likely extend to all of your volunteers and contractors, obviously, as well as your employees. And the COVID-19 creates an additional risk, and forward thinking, or even doing it now, would suggest that that risk is considered by whoever is in charge of health and safety, or your health and safety committee, and say, well, look, what are we doing at each level? Have a plan for 4, 3, 2, and 1 around the risks of COVID-19, and how we're going to mitigate those risks. So how are we going to safely operate and protect our employees, our volunteers, our contractors, our participants in events? And a lot of that will be taken from guidance from the government. I see, for example, contact sport won't happen until we're down to level 1. But a lot of businesses are now coming, and organisations are now coming out saying, well, this is how we're going to operate at each level. For example, my own firm's just released our health and safety policy for each level around meetings with clients and hand sanitizer and all sorts of what we can and can't do, and how we're looking to mitigate the risks, because that's all of what health and safety is about. It's about identifying the risks, and then how you're going to mitigate those risks, and then reviewing to make sure that your plan is working. So I'd really recommend plan how each level of COVID-19 affects your staff, your volunteers, your participants, and then how your organisation is going to mitigate that going forward. And again, that could just be half a page per level kind of thing, and taking the basic steps of social distancing, 2 meters, hand sanitizer, and that kind of thing. So other assistance for incorporated societies. The government has signalled that they're urgently looking at legislative change to allow incorporated societies leeway here, and this also applies for companies too, but incorporated societies is our focus today. So the registrar of the societies register can temporarily extend deadlines. So if your financial statements were due at some time during this period, and for whatever reason you haven't been able to get that to them, you just get in touch with the registrar and let them know, and that's one way to prevent being struck off the register for not complying with your obligations there. What if you've missed your AGM, or your AGM's coming up and you're not sure if you can have it? Again, there'll be temporary relief for organisations unable to comply with the requirements in their constitutional rules. So I wouldn't be too worried around the fact that your AGM's coming up and it might not be possible. Equally, we have advised clients that it is possible to hold an AGM by Zoom. Now, that would normally depend on what's in their constitutional rules. So that's a bit of a case-by-case basis, but that is one option that we've seen organisations take up, especially, and I don't think it's as relevant for regional organisations, but when you've got a national organisation and flights aren't really operating, or come July, August, might still not be at the level where it's viable to have an AGM where everyone attends in person, it's good to look at alternate options there. Electronic signatures, the rules around those have been heavily relaxed in this current climate, and they are mainly accepted for all sorts of documents. Where you possibly might still run into an issue is when you're looking at bank documents or getting a mortgage or things like that. But if you're signing, say, your financial statements to send through, then electronic signatures are definitely going to be accepted in those circumstances. What if you're in debt? Good question. Or there are some issues regarding the financial viability of the organisation. So normally in this situation for a company, directors would be personally liable for anything that happens if the company continues to trade while insolvent. Technically, they should be seeking receivership or liquidation advice as soon as they realise they're insolvent. But the temporary changes, and I should note these are all only temporary changes for this time, there are further protections for companies and businesses to keep trading during this period, even if they know they're insolvent. That's just a recognition that times are tough, and while this period might be really tough, we're hoping there's going to be enough extraordinary support from the governments to move out and move up after we get through this period. So that's what they're urgently looking into place around that, or urgently looking to put into place around that. And now my last slide here is talking about the new Incorporated Societies Act, which might affect a lot of us going forward. The old Act came into power in 1908, so this new Act is long overdue. I expect it in the next year or so, and I am cautious about that time frame, as I've been saying. I've been expecting it in the next year or so for the last 2 years now. The speed of the change has been incredibly slow, and it's one of those acts that keeps getting pushed to the bottom of the pile whenever anything else comes up. So I can easily see that this might be pushed back further. However, it will come into play at some stage in the next year or so, and it will have an impact on every incorporated society currently. So the key changes are it's going to introduce duties for officers. So that's your president, your secretary, your treasurer, similar to those of directors in companies, where it's a criminal offence to breach those duties. So when we have the final act, it would be good for every organisation to have a list of those duties and provide them to officers or potential officers going forward. It's going to provide a procedure or a specified procedure for dealing with conflicts of interest. Now, most organisations will have something around this as a matter of best practice, but this will be a specified procedure for everyone to follow, which is quite helpful. It's going to require everyone's constitution to contain a disputes resolution procedure. Now, this is where we find most of our organisations don't have this in their constitution currently. And that's something to think of going forward, because they haven't provided the exact wording or the finalised wording around what that would look like yet, although they are considering having a standard disputes resolution clause. However, for each organisation, it should almost be done on a case-by-case basis, because each organisation is going to have different requirements and different needs around their members and what disputes could look like. And certainly in sport, we know there can be a lot of disputes, whether that's around the rules while in play or in game, or complaints about misconduct between members, or even complaints from the public about the organisation or what members within the organisation have done. We at Gibson Sheet, we really see organisations trip up when it comes to managing disputes or complaints processes, and a lot of what I've worked on for a number of national sporting organisations over the last 3 or 4 years has been making sure there's a really good rules system and dispute system in place. So all they need to do is follow the steps rather than go, oh, we don't actually have anything around how to guide us there, because that's where you get problems. So I think that'll be the biggest change to everyone's constitution, is having that disputes resolution procedure in there in some way. And there's a few other smaller requirements for constitutions, and to be honest, we've been reviewing quite a few incorporated societies constitutions over the last 6 months, and most are already compliant with the new requirements that'll come out with this new act. But it is something to bear in mind going forward, is that when this act comes in, you'll have a transition period of 2.5 years to make sure you're compliant with the act. I'm hearing that it's not going to be compulsory, but if you don't, then you will no longer be an incorporated society. So if you want to remain an incorporated society, then it is essentially compulsory. So that's something to have a think about going forward, is that your constitution will likely need a review. And then there's two options for this. You could potentially wait until the Act's passed, and then you've got absolute certainty about what does and doesn't need to be in there. Although we do have a really good picture of what's in there now, and if you were looking at a review, you could think about that fairly soon. And then once the Act's passed, you could review how everything's working and go from there. That might be best practice. But certainly food for thought going forward for all of our incorporated societies. Question time. Look, I hope I've seen a list of questions that have come in. I hope I've answered them all. I think there was a part-time versus casual question out there, or something to do with how do we know what's going to happen with staff? When can we let them know we're giving them work again? From what I take away from that question was, we've got staff that are either part-time or casual, and there's no work for them at the moment, so they're not working, and we might not have work for them going forward. So what do we do? What do we do there? And my answer for that would be, firstly, it depends on if they're part-time or casual. If they're a casual employee, the relationship there is much easier to manage, as it's simply an agreement that if we've got work and we offer it to you, you may accept, but we have no obligation to offer you work, and you have no obligation to accept that work. If they're a part-time employee and there's a specified number of hours that they're supposed to be doing, even if that's a minimum, the relationship's a bit trickier. They're a permanent employee, and that relationship can only be ended after following a proper process for whatever reason, whether that's redundancy or something else. And my advice around employees and going forward is organisations should be planning what's going to happen at the end of the wage subsidy period now. You need to have an idea of what your organisation is going to look like and what you might need to do within current constraints and constraints that you have going forward to really plan and identify what the organisation is going to look like, or what it might need to look like when you get to the end of the wage subsidy. Another question that came through earlier was around volunteers. And I think I've talked about health and safety there with them already, and that the legal obligations around volunteers haven't changed. Additionally, I would recommend that every organisation has a volunteer agreement in place for their volunteers. This is best practice. It could be as simple as, well, most examples that we've seen are one page, and it's just simply noting, yes, I know I'm a volunteer, I'm not an employee. I agree to abide by all policies that are notified to me, and that should include the health and safety policy. And the rest of it's usually specific to the organisation or the event they're volunteering for. But it's certainly best practice to have a volunteer agreement in place between the organisation and the volunteer. There were a few other questions, but I hope I've clarified those throughout this presentation. But I'll just open it up now to everyone. I'm not sure if we want to open it up on voice or if people want to put the questions in the chat.
Richard, it's just Alison here. If people have any additional questions, just pop them in the chat function.
Yep.
And whilst you're doing that, I have some additional questions for you to answer, Richard. So this question was about ACC. So there's two parts to it. The first part is, what are the obligations regarding the wage subsidy if an employee goes on to ACC because of an injury? And then the second part is, in addition, ACC pay 80% of the wage. What happens regarding the wage subsidy if we choose to top up that employee's wage? Can we apply the subsidy to that amount?
Great question. Excellent question. Now, look, this is one of those areas that hasn't been clarified by ACC or the government at this point. So for an employee that is on ACC, after the first week, ACC do pay 80% of their salary. And from what I'm hearing, the question is, well, if we've applied for the wage subsidy for that employee as well, what do we do with that money? Now, one of the requirements of the wage subsidy is that it is applied in full to the employee. However, that might end up with the employee getting more than 100% of their salary. What I would be recommending in this circumstance is getting in touch with ACC and saying, hey, look, we've applied for the wage subsidy for this employee, and 80% of what you're paying plus the wage subsidy is more than 100%, and then work out with ACC what the percentages are that's going to be paid to make it up to 100%. So ACC might end up paying less. And up until that point, I'd certainly be holding on to that money and not applying it to any other purpose. If you did, that might not look good in a wash-up situation. So yeah, I'd be communicating with ACC on that and saying, hey, look, we've got the wage subsidy. We're required to pay this to the employee, and therefore they might be getting more. So we need to work with you to make sure it's 100%. Because if you did have that wage subsidy and paid it to the employee as well as ACC paying 80%, there might be a breach of some obligations with ACC there, and they wouldn't be too happy about the situation either. We haven't seen any guidance on this whatsoever, so that's just our advice at this point. But really good question, yeah.
Thank you. And then just a little bit of clarity around the wage subsidy. So one question is, what are the rules re wage subsidy if your company has been active for more than a year, but historically at a very low level, however, has had rapid growth in the past 6 months? So compared with this period last year is coming up significantly higher.
Yep, another really good question. You can take more of a recent approach to your decline. So if you look at the months immediately before this all started, and if you've had a 30% decline there, that's fine. What I would be doing, and I think I've recommended this earlier, is just making sure you're documenting that and saying, look, we have experienced this decline from X month to Y month. No, it's not a year beforehand, as the requirements say, but the reason why we're comparing it to this month rather than a year beforehand is this, and just having that document ready to go. So if anyone asks a question about it, you're set up.
And then the last question I've got that was submitted prior was just reconfirming, what do we need to be aware of if we are reducing an employee's hours?
Yes, another good question. So look, that goes back to employment law, and your obligations under employment law are not affected by any of this. So a proposal to reduce an employee's hours is simply that. It's a proposal first, and you've got to follow a proper process. It should be done in good faith with meaningful consultation with the affected employees. So I think, as I said, I would recommend that it's attempted to be done by agreement first. So this is what we're thinking of doing. This is why we're thinking of doing it. And we're happy to answer any questions or hear from you about this, but we'd like to have you agree or otherwise by X date. Now, the second stage is imposing that, and that again is that proper process. If you and it's proposal, consultation, decision. After considering the feedback. Again, I would recommend the best way to do it is to seek agreements. It keeps that relationship with staff much better than simply imposing it on people. And our experience is that staff are keen and happy, or not necessarily happy or keen, but are willing to accept the agreements, given that other options are drastically worse for staff, being possible redundancy. Again, I would just really recommend that everything you do is documented, why you're doing it, and what you're doing.
Thanks, Richard. No other questions have come up in the chat function. So I'll just pass over to Roger Thompson to just wrap up the meeting.
Okay, thanks, Alison, and thanks, Richard. I've got to say, yeah, lots of very good questions, and I'm sure that what you just provided will have added a lot of value to the people on the call. So thanks to Richard for joining us from Gibson Sheet, which we appreciate. Thanks to Alison, who's our business manager at Sport Wellington and sort of our resident go-to HR person. And also to everybody joining this call. I know there are 12 stakeholders on this call, and I'm really mindful that there will be people on this call that have paid staffing issues that hopefully this advice today has helped with. And there are other people on the call that they're leading or they're involved in purely voluntary organisations. So thanks, Richard, for sort of sitting across the different examples and being mindful of that. Before I close, I just wanted to point out something I think that's quite important. There are a number of organisations right now, regionally and nationally, that are grappling with what delivery of physical activity, or it might just be competitive sport, let's just say it's basketball, at different levels looks like. I know we're all grappling with that, and different sports are being proactive and sending out information. And at the end of the day, Sport New Zealand are working really closely with the Ministry of Health in particular to get tighter and tighter on the guidelines for physical activity. And I'm just pointing this out because it comes back to a number of the health and safety related examples you touched on, Richard, and that every week, as you all know probably, that Sport NZ will be promoting the latest guidelines for physical activity, including play, active, rec and sport. But then, as Richard started to touch on from a health and safety perspective, then what we're all thinking about is, well, what does that mean for delivering, let's just say it's volleyball at alert level 2 or alert level 3? And then the next step that Richard touched on was, what does that mean for health and safety? What are, Richard, the obligations of volunteers? I know I've got a number of good friends who are chomping at the bit to get to alert level 2 and start running sport team trainings with physical distancing. Now, just the obligations of them as volunteers, everybody will be looking for very, very clear guidelines on this. So where I'm going with this is I'd encourage you all to subscribe to the Sport Wellington e-newsletter that we send every Friday. In that e-newsletter, we are genuinely looking to make sure we have the latest information in there, and the links, the latest information from physical activity guidelines to delivery of sport at different levels. And then we'll be making sure that we include information around the development of appropriate, for example, contact tracing system, Richard. So a number of organisations are grappling with that as well. So if you haven't already, I really encourage you to subscribe to the e-newsletter that comes out every Friday. Just email us at info@sportwellington.org.nz with your details, and you'll get that every Friday with the latest information. And there'll be a lot of value in that, especially when it comes to health and safety and delivering physical activity, or let's say it's competitive sport, to your own stakeholders. So I just wanted to point that out. Just from here, we will be putting the recording of this conversation on our website. And what I'd encourage you to do again is to sign up to the e-newsletter. Then when it comes out, you can forward it to anybody within your own club or organisation, so they can also have a listen to get up to speed where they need to. Any follow-up questions that you have, and it's no problem whether you're a voluntary organisation or a organisation with paid staff, really encourage you to be proactive and just coming back to Sport Wellington through info@sportwellington.org.nz, and we will absolutely respond to you within 24 hours. We appreciate just looking to do our best to walk in your shoes regarding the pressure that you're all under. So please be proactive in coming back to us. And just the last thing is I'm certainly going to work with my team, Alison, and come back to Richard, because I believe 12 stakeholders hopefully got some good benefit out of this session today. But there are a vast number of stakeholders out there that I believe would also benefit from a follow-up session next week. So we'll explore that pretty quickly and promote that. So once again, thanks, Richard. Excellent. And Alison for putting this together. Okay, everybody, have a great day. Stay well. Kia ora.